Okay, I see the recording is also in progress. So let's start today's debate. I would request everyone to switch on their cameras, the participants only, please. Great. So I welcome everyone for today's debate. The motion for the debate is that this House believes that exception 2, which is the exception of marital rape to Section 375 of Indian Penal Code, is constitutionally valid. So we have Mr. Anurag Pandey and Anurag Iyer who are speaking for the motion. And we have Aditi, Pundhir, and Ajay Sharma who are speaking against the motion. A few fun facts about people who are participating in today's debate. And this is something that they have told us. So I'm not going to be judging anyone for it. Um, so Anurag Pandey, who's an associate with PSL Advocates and Solicitors, enjoys reading up on technology and true crimes. I mean, I think true crimes quite dark for someone to follow. And he's also a frequent Redditor and an amateur comic. Um, Amateur comic, I think he does crack a lot of bad jokes. So I think amateur to that extent sounds sort of fair. The other one joining Anurag Pandey is Anurag Iyer. He's also an associate with PSL Advocates and Solicitors. He likes to play football, video games, and is a die-hard Game of Thrones fan. Against the motion, we have Aditi Pundhir, who is a senior associate with PSL Advocates and Solicitors. She is enthusiastic towards crime news sports. In fact, she and play quite a bit together, or at least have started to play quite a bit together. Uh, enjoys reading self-help books and cooking occasionally. Ajay Sharma is an associate with PSL Advocates and Solicitors. He enjoys basketball and has an active interest in following political. I mean, his political inclination, in fact, we showcased today when he goes to different presses. So for all of you, one second, I think. I would request everyone who is not participating or is not a speaker, I would request everyone to be on mute. Thank you. Thank you. So for all of those who do not know what Oxford style debating is, I'm just going to give a brief overview and then we'll start with the process. So in this kind of debating style, you have opening votes. So if anyone believes for the motion or against the motion, have to go ahead and do a pre-voting, have to participate in pre-voting, and their votes will then be calculated and seen, whoever is for the motion and whoever is against the motion. Then the participants would go ahead and make their submission supporting the motion or against the motion. And subsequently, at the end of it, another round of voting will be conducted, in which the main thing which will be seen is how many votes in fact were shifted from their original stance, and that's called the swing voting system, and that's what something going to be adopted. Whoever gets the most number of swing votes in fact would be the winner of today's debating competition. And with this, we would start with the first speaker, and I'm assuming it's for the motion. Is that right? That's great. So first speaker for the motion.
We'll have the voting before it.
No, absolutely. First speaker for the motion is Mr. Anurag Pandey.
Mr. Iyer.
Okay, Anurag Iyer is the first speaker. I think in my list it's incorrectly written. Before we start with the entire debating, I would request everyone to go ahead and give their votes in the chat box, whether they're for the motion or against the motion, whether they believe in the motion or they're against the motion. And I would request them to do it right now. This would, in fact, be very critical for the people who are speaking today, because they'll know whoever has a bigger burden to discharge in today's debate.
Hey, I just wanted one clarification. Do we also get to vote?
No, I mean, that'll be 2 on 2, right? So anyway, it'll be cancelled. Unless you want to go ahead and have, if you have confidence on your side, you may want to support the other side. Uh, all right. I'll wait for another minute and then I'll just disclose the results. As is evident, 90% of the people are against the motion, and I'll give the exact number as soon as the voting is done. Who's voting for PSL? Because PSL is for the motion. Okay, so the pre-voting is concluded. We have 21 votes against the motion, and we have 3 votes for the motion. With this, I would now hand it over to the first speaker supporting the motion. And Anurag, now everything is for you to go ahead and discharge your burden. Good luck. You're not audible, Anurag. I would request you to just check your... You're still not audible. Is there something wrong with my speaker system, or can anyone hear Anurag?
No, we can't hear him. There seems to be some problem with his mic. He's still muted at the moment, though.
So everyone, there were a few last minute votes which have just been put in the chat box. So the revised votes are 25 against the motion and 4 for the motion.
Am I audible now?
Yes, you are, but you're not visible now.
There would be 2 because I've actually connected for the voice through my phone.
Yes, you're visible.
Perfect. So let's begin, Anurag.
Okay. Thank you, ma'am, and a very good evening to everyone present here. Thank you for taking time on a Saturday evening to sit and have this debate with all of us. So I can see that the house is tilting against the motion. I will do my best to convince the house otherwise over the course of my submissions here. And I believe the best start to my opening statement would be to lay out the exact issue at hand, so there is no misunderstanding that prevails over the course of the future discussion. Before I even begin, the exception to, I believe most of the people here would be aware of what it is. It essentially refers to sexual intercourse or sexual acts between a man and his wife. And section 375 relates to rape, and exception 2 relates to how, in the context of a marriage, if sexual acts are committed, they are not going to be falling within the definition of rape. The restricted issue before us is to assess whether such an exception is constitutionally valid or not. While stating this, I would like to put a disclaimer out here that we do not, over the course of my submissions, me and my co-speaker do not in any way condone spousal sexual violence. We believe it is not right. Neither is it our submission that this exception would in any way entitle the husband to engage in non-consensual sex. The only assessment, the restricted assessment that we have to do today is whether or not we can label it a rape. That would be the limited contours of our analysis today. That whether a non-consensual act between a wife and a husband can be labeled a rape or not. I urge this house to keep this in mind till the end of the discussion that happens, because anything aside from this would frustrate the purpose of having this motion altogether and the assessment of constitutionality that follows it. Keeping this in mind, it is one of the first things that I would like to submit to this house is that this particular exception was inserted in the year 1860. It has been retained till date, and it has been the subject matter of several discussions before a great number of authorities, great number of law commissions, sitting with juridical practitioners who have assessed the legitimacy of this exception. As on date, I submit the constitutionality of this exception stands to be valid. As on date, it is not unconstitutional. As on date, it has not been declared unconstitutional. Just since it remains to be a constitutional legislation as on date, the principles of presumption of constitutionality continue to apply. So my first submission before this house is, given this principle, the assessment of this exception must be done in light of this principle, that this exception must be presumed constitutional until there are reasons to believe otherwise. Even though this was enacted prior to the Constitution, it has undergone a lot of tests even post independence, and therefore there is no reason why we must not afford the presumption of constitutionality to this particular exception. One of the major understandings of principles of constitutionality also is this, that at no point of time can we make, if it's possible to harmonize and leave the exception in existence, we must try to do so. The whole purpose of us having a legislature and electing a legislature, leaving it to their wisdom to decide laws, and then thereafter verify it on limited contours and limited parameters as given under part 3, is because we respect the wisdom of the legislature, which reflects the will of the people. I urge this house today to please keep this principle in mind as we go ahead and assess the legitimacy of this provision. Keeping this in mind, I will jump straight right to the main issue, which is, in my humble opinion, labeling it a rape would not be correct. In my humble opinion and my co-speaker's humble opinion, the exception is valid and must stay the way it is. Over the course of my submissions, I would like to first state the purpose that has been laid out as the reason behind this exception. Without understanding the purpose of this exception, merely looking at the purpose of having rape altogether serves no point. The purpose of this exception, essentially, as has been reiterated while the provision was being drafted, as is being reiterated by law commissions for quite some time, and which I believe would be a legitimate reason, is protecting the institution of marriage. That is the purpose of this exception. To this, I also submit to this house that marriage as a concept, or marriage as an institution, or marriage between two individuals, is something that this country has for quite some time treated differently as a class. Marriage has several elements to it. In fact, around the institution of marriage, you have several laws, be it restitution of conjugal rights, be it divorce, be it maintenance, be it child support. There is an entire act, for example, the Hindu Marriage Act or the Special Marriage Act, exclusively built for the purpose of marriage. I urge to this house, one of the first reasons why marriage needs to be treated distinctly is this itself. Marriage is a separate class, is treated differently. It's treated differently to an extent where conjugal rights are an expectation. So much so that the court has the power to enforce something called as the restitution of conjugal rights. Again, this does not entitle, let me reiterate, this does not entitle the husband to commit spousal sexual violence. I will come to that in just a bit, but this I would like to reiterate here because there is going to be a misunderstanding otherwise, which I would like to keep clear. In the context of rape, specifically, when some sort of an activity between a husband and wife is labeled as a rape, there are multitude implications that come to the marital bond or the marital relationship that exists in place. As an institution, marriage is supposed to be an extensively private affair between the husband and the wife alone. For the state to interfere and to look into such aspects, when in fact, the state actually tries to keep the marriage going and makes efforts through the means of restitution of conjugal rights, makes efforts through the means of provisions such as 376B of the IPC, there is evident indication that marriage is a separate class. All we are saying is if there is a woman who's suffering certain victimization or facing certain issues in a marriage, while she may very well avail her remedies for spousal sexual violence under 498A and relevant provisions of Domestic Violence Act, it is our opinion and our submission to this house that definitely, certainly it cannot be labeled a rape. It will lead to the entire familial structure, be it the children in the marriage, be it both the persons in the marriage being in a very difficult situation in terms of handling their own family. It will be an interference with the familial structure that we have put in place in the society, where we promote the concept of the marriage, promote and hope that not many people get into divorces. Mandated restitution period is provided under the legislations of Marriage Act. I urge this house to look at this. Additionally, I also submit to this house that another important point that needs to be understood in the context of marriage, and this is an indication from our Indian Penal Code. After the Constitution was amended, under Section 376B, recently, the insertion of 376B happened, which clearly provided that when the husband and the wife are separated, then punishment for rape may be meted out. Even there, separately, there is a preliminary inquiry and a process. If the house, my time is up, I seek just a minute's extension from the learned moderator, if it's possible. I will conclude my submissions in a minute.
I'll give you 30 seconds more.
Sure. The provision of 376B clearly provides that a punishment of just 2 to 5 years, 2 to 7 years around that would be imposed. It also, in its objectives, clearly was meant to be created in this way so that the husband and wife can get back together. I urge this house to look at this. It would be incongruous to treat the husband in a marriage differently from a husband who has been separated from his wife. And that is not the subject matter of the challenge today. 376B is not the subject matter of the challenge today. I urge the house to look at it or look at this. And I urge the house to also put the persons who have voted against the motion to relevant proof in the context of the presumption of constitutionality. Because they have to establish how they are not a separate class, which I don't believe there is any reason to look at. That is all from my side. Thank you.
Thank you, Anurag. I'll equally give 30 seconds more to every speaker so that it's equal for every participant. And another thing I would request you, in fact, I wanted to go ahead and make this disclaimer at the very outset, is that whatever bias that one person may have to the motion, I would request everyone to be just open-minded whenever they are voting and listening to all the submissions and be very objective in their analysis. So now I would request the first speaker against the motion to address her submissions in this regard.
Thank you so much, ma'am. Good evening, everyone. I would be speaking first, and the second part would be dealt by Aditi. So, as Anurag said, that we have two major issues to deal here. Firstly, that the marriage falls under a different class, and secondly, the major point which he raised, that the women, means the wife, she has a remedy under Domestic Violence Act or other provisions. And third major issue he raised, the constitutional validity. So before I rebut his point, I would like to point out few points, like why this exception exception number 2 of 375, section 375 should be struck down, and why this is unconstitutional and invalid. This is the reason is, if you go by the exception, I will read it for it. It says sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age is not a rape. Though it was amended, the age went up to I think 18. So this exception itself is vague, arbitrary, and ambiguous. I'd explain you how. So behind this exception, the husbands take a defense that there is no concept of consensual sex or a forceful. There is nothing called consensual sex, or I would say consent required for a sex in the marriage, because it's a different class. There are a lot of lacuna which I would explain it in the later part. So the only argument which put forward by the Anurag or those who are in the favor of this motion is that there is a intelligible differential that you can differentiate. There are different classes. There is class of married, there is a class of unmarried couples, and the same was reiterated by the Justice Hari Shankar in his judgment. Each and every time he countered each and everything by this intangible differentia, by saying that there are two separate classes, married couple and unmarried couple. So as Anurag said, this was drafted in 1837. The first draft came in 1837. It became legislation in 1860, and now we are in 2022 and discussing this exception. So the object behind this exception was to protect the institution of marriage, or I would say that conjugal rights between the wife and husband. So whether it's protecting the wife, here this object, this intelligible differentiation, not protecting wife or not helping anyone, it's only affecting the wife specifically. So especially wife. So last night when I was going through the research, I was doing a research, I found few articles and few videos also. So how this exception harms the wife, I explain you. In India, when I talk about India, I do not talk about the 10% of people who lives in the Delhi, Bombay, or Bangalore. I talk about the 90% who lives in a suburban or a rural India, where a girl do not know whom she is getting married. What is the purpose of this marriage? She do not know what is the institution of marriage. So see, on the force she is getting married, she don't know what is consensual sex, what is sex, and what is rape. But her father forced for the marriage. See, like in suburban areas, in areas they get married at early ages at 18, 21, 20. So without their consent, without wife's consent, without the girl's consent, the husband forcefully sexual intercourse, and then after not only sexual intercourse, abuse, which I feel fall under the rape. My only submission is that whatever sexual acts, event, or intercourse fall under section 375, then that shall be treated as a rape, whether despite the fact whether that rape or that sexual event or intercourse committed between the husband-wife, between the married couple, or between the unmarried couple. You have to treat a rape in the same manner between the married couple and the unmarried couple. There is no distinction. There is no there is no distinction in rape. You can't say the cruelty and rape, that a wife can go ahead and lodge a complaint under section 498A, not under section 375 of IPC. So you can. The rape is different, and the 498 is different, completely different. The provisions section 3 of DV Act, that is different. So she has a right to avail remedy under section 3 of the Domestic Violence Act, or or the 498A, but that would not be equivalent to rape. Here, the point is that this exception, which is outdated, vague, unambiguous, not only harming the society, not only harming that lady, that wife, but it's also harming a society, because in IPC this is not a civil, this is a crime. The rape is a crime, and this is an offense against the state. This is an offense against the society at large. You cannot. So this is just perpetrator here. Comes that you are trying to distinguish this offense on the basis of relationship, between which relationship. You can't distinguish the crime on the basis of relationship. Crime is crime, rape is rape. You can't say that the girl entering into a marriage, she had given the consent for forceful sex or for any kind of sex. She had given the consent for the marriage, not for the forceful sex or any kind of rape, which falls under section 375. May I request for 30 seconds?
Then I would actually have to deduct it from Aditi's time. If you're okay with that, then we can do that. 10 seconds to conclude, please.
All right, thank you so much, ma'am. So as I said, the intelligible differential that the defense taken by the Anuraag or whoever argue in the favor of this exception is the object is not solving the purpose. This is a problem, and we cannot say that the rape is different, and then when the girls enter into a marriage, or when the wife, they can't be a rape. If that action or event fall under the definition of...
Your time's up. I would request Anurag Pandey to now speak for the motion. Thank you so much, Ajay. Thank you.
Thank you, ma'am. I hope I'm audible.
You are. You're both audible and visible.
Perfect. Thank you. Ladies and gentlemen, a very good evening to this August gathering, which has very willingly agreed to devote their beautiful Saturday evening to a debate on a motion much worthy of our time and attention. Much has been spoken already on the motion, which is essentially, as of today, just a fact. The motion simply states that this House believes that exception 2 of section 375 of the Indian Penal Code is constitutionally valid. This is the essence of the motion. For ease of reference, I would refer to this as just the exception. Since my learned co-speaker, Mr. Iyer, has dealt in part with the presumption of constitutionality, qua the proviso to section 375, I would crave leave of the House to delve deeper into what lies behind the motion. In order to be able to consider the real question behind why we have all gathered here today, it is apposite to consider the question of why the exception to the offense of rape has, despite numerous challenges to it, continued to find its way into our statute books. Allow me to assume on behalf of every single person present in this House that we are not opposed to criminalization of spousal sexual offenses, specifically non-consensual sex between spouses or those in spousal-like relationships. In fact, there already exists a legal and penal framework for spousal sexual offenses. It is certainly not my case that husbands or men have the right to impose themselves on their wives or spouses, citing marriage as the be-all and end-all of consent. However, the legitimate concerns surrounding the motion cannot be and must not be brushed aside with ad hominem accusations of patriarchy, since that has the effect of shutting down any sane and balanced discussion on an issue that could benefit from a plurality of diverse perspectives and inputs. It is imperative to separate the motion from the emotion before we take on the nuances of the issues at hand. I'd endeavor to aid this House's understanding on 2 primary grounds. First one being that the legal framework to address and provide remedy against spousal sexual violence is already in place. The legislature, through the exception and through the creation of a separate legal ecosystem for dealing with spousal sexual offense, has indeed criminalized it, just without terming it rape within the meaning of section 375 of the IPC. The provisions of the Domestic Violence Act, in addition to the provisions such as 498A of the IPC, itself constitute the legal framework granting recourse to the women who might find themselves in an unfortunate position in their marriage. Section 376B of the IPC, which penalizes sexual intercourse against the consent of the wife during separation, and Section 498 of the IPC are proof of the intelligible differentia that has been spoken about by my learned speakers, underlying the existence of the said provision as well as the exception, namely a legitimate and different treatment of offenses committed within the bounds of marriage and in the event of a legal or de facto separation. Sorry. Over the years and through various law commission reports, the exception has undergone the process of Indianization after the coming into force of the Constitution, which is evident from several parliamentary cogitations and the amendments effected to the IPC along with the CRPC. This is because legal machinery under various acts houses provisions that accord counterbalancing protection to the women. That brings me to my second and the most important ground. Laws are but codified social norms. The impracticality of enacting an unenforceable law is likely to do more harm than good. In terms of Section 114A of the Evidence Act, ladies and gentlemen, there exists a presumption of absence of consent in cases where sexual intercourse by the accused is proved. And if the question is surrounding the consent of the woman alleging rape, and she states before the court that she did not consent, the court presumes that she did not consent. Now, allow me to explain to you how this takes the law over its head. It is not outlandish to assume that a married couple is at liberty to engage in conjugal activities on a frequent basis. In this factual matrix, when the act under question is on a sudden occasion brought under question and an allegation as serious as that of rape is made, the laws governing its adjudication would appear to fail one particular spouse, which is the husband. It's a no-brainer to say that this is because these laws were made with a protectionist mindset, which I refer to as Indianization, with a view to counterbalance the freedom the man supposedly enjoys in a marital relationship. But why? Why is a question we must ask ourselves. Why go the extra mile to make one party be on a lower rung as opposed to the other and give the other party a crutch to climb with? The answer to that, ladies and gentlemen, is society and the preservation thereof. Family, which is a fundamental unit of society, needs as much protection from itself as it does from the state. Ladies and gentlemen, if a woman forming part of a married couple alleges rape by the husband on a certain day, it is the word of the accuser pitted against the words of the accused. Yet, the law presumes that the word of the woman is already proved, leaving the onus of proving his innocence on the man. And what comes of the child born of such wedlock? He's the child of a rapist. It is apposite to add that the opposition's primary concern does not seem to be the removal of the exception, but the branding of the husband as a rapist, the moment an allegation is made. Please bear in mind that alternate remedies specifically crafted in the factual and societal context of our society continue to remain available. It is with the intent to protect, preserve, and have minimal interference in the affairs of a married couple that the state has retained the exception while granting the women other ways to safeguard their life and liberty. To close the arguments in favor of the motion, I state that trust, dignity, and respect form the basis of a marriage and that it is a two-way street. I must state that violence against the spouse, mostly a creature of either one's or their family's choosing, is not just vile, but abhorrent and despicable. Please note that how I say spouse and not husband or wife, because violence, ladies and gentlemen, does not have a gender. But I guess that's a motion for another debate. Regardless, having your trust in a person obliterated in a way,
I would like
I'll just take 10 more seconds, ma'am, please. Just 10 more.
All right, 10 more seconds.
Keeping aside the occurrences of false complaints and malicious prosecution, one might say that the punishment awarded to a husband accused of offense of rape is different from that awarded to any other person. Is it inadequate? Arguable. But is it unconstitutional? Certainly not, because inadequacy does not constitute unconstitutionality. That's my time. Thank you.
Thank you so much, Anurag. I would give 10 extra seconds to Aditi to begin with.
Thanks a lot. Hi, everyone. My name is Aditi, and I'm going to be speaking against the motion. And to begin my summations, I'd like to state first that basically the whole argument by the parties for the motion, as stated, number one is that their first argument is basically that the marital rape, this exception, protects the institution of marriage. Now, on that note, I would like to firstly submit that it is not the criminalization of marital rape which destroys the institution of marriage. It is the marital rape itself that destroys the institution of marriage. So on that note, I'd like to begin my first submission. Since we've already discussed all the basic, everybody is already aware that the motion is exception 2 of section 375 is constitutional. Now, I'd like to first begin my submissions by stating the objective of rape. Now, since it has already been stated that this exception has its roots way back in 1860. So it is an age-old exception. And we are living today in a modern day world where marriages are between two individuals who have equal rights and equal liberties. And it is not after women marry a man, they do not subordinate themselves before the men, and they do not subjugate all their rights before their men. So just because a woman marries a man, there is no assumption that there is an undeniable access to sex which is being given by her. Even after marriage, the woman has a right to withdraw her consent at any point of time. And there may be many instances which the exception to fails to recognize. For example, the women may be sick, the man may be sick, or there may be some communicable diseases. There may be 100 instances where a woman does not want to have sex. But as per the section, you cannot penalize a man for forcefully having sex with a woman because it is not considered as a rape. So I'd like to say that my submission would be that exception 2 creates a classification between married and unmarried women. On one hand, section 375 grants right to an unmarried woman to prosecute her offender under the provisions of IPC. But on the other hand, unmarried woman has been denied this right. So therefore, my submission is that this is an unreasonable classification. Now, the argument raised by the other party for the motion is that it is not an unreasonable classification. It is an intelligible differentia, which is premised on the fact that in marriage there is a consent. The woman has already chosen her sexual partner, so there is a consent. I'm sorry, I'll take a second. There is a legitimate expectation of sex. So on that note, I would like to submit that legitimate expectation of sex does not mean undeniable access to sex, and it does not mean that a woman cannot withdraw her consent. Now I'd like to move on my second. Now I'd like to very quickly deal with the submissions made by the party for the motion. Anurag is submitted that there are many provisions under Domestic Violence Act which deal with offences such as Section 498A of Domestic Violence Act. On that note, I'd like to submit that those provisions do not anywhere deal with the offence of rape. Those are provisions with respect to which deal with cruelty faced by women from her husband and her relatives. Another argument which was raised by the parties for the motion is that the parties also have the courts also support conjugal rights and restitution of conjugal rights. On that note, I would submit that even that is subject to consent of both the parties. The courts also do not force a party who is not giving consent to have conjugal rights or for restitution of conjugal rights. Even in that aspect, consent has to be seen. So my submission is that exception 2 of section 375 fails to deal with the main objective of the rape law, that is consent. It fails to recognize that after marriage, a married woman does not give undeniable sex to have undeniable access to sex, and it does not mean that she cannot withdraw her consent at any point given in time. Now, my first submission is that exception 2 of section 375 is violative of Article 14 on the ground that it creates a classification between married and unmarried women, where married women can prosecute their offenders and unmarried women has no right to prosecute the offender. My second submission is that it is violative of Article 21 also, because when a woman is subjected to rape, it is not only a physical injury, it is also a mental injury, it's a psychological injury. So this exception treats privacy of marriage before privacy of individual, or before the privacy of an woman over her body. So my summation, the other summation would be that this is violative of Article 21, as it fails to recognize the privacy of a woman over her body and her individuality, and it treats privacy of marriage before the privacy of a body. This would be my second submission. Do I still have time left?
You have 45 seconds left.
Okay. So I'll quickly summarize my arguments by sharing this data that as per UN population fund, more than 2/3 of married women in India, aged between 15 to 46 years, have been brutally have been beaten up, subjected to forced sex, and have been raped by their husbands. So marital rape is a reality, and the fact and the argument that marital rape would destroy the institution of marriage has no validity, because I believe that institution of marriage is itself destroyed the day marital rape occurs. Thank you.
Thank you. Who would be taking rebuttals from speakers for the motion?
Anurag, you want to take that? All right. In case there's any place where I would want to pitch in, is that permissible?
That is permissible, provided you stick within the 2 minutes time frame.
Sounds good. Sounds good.
Start, Anurag.
Am I audible?
Yes.
All right. Thank you, ma'am, and thank you for the speakers on behalf of the opposition as well. So I'll go point by point as I have heard and been able to gather from the submissions. First, with reference to presumption of constitutionality, we are yet to receive any response with reference to this, and basis this. So entire analysis happened bereft of the understanding of the presumption altogether. So that's my first submission before this house. Second, there was a mention of a statement that woman has the right to withdraw consent. Neither of us, me or my co-speaker, say that she cannot withdraw consent. What we are in fact saying is that the labeling of it as a term rape should not be done, which is quite distinct from saying that we support that she should not be giving consent or any of this. In fact, we say there is another framework in place for this very issue. So I urge before this house that is also taken care of. Third, there was a mention of us talking about the restitution of conjugal rights and saying that conjugal rights, what we were trying to essentially highlight through this is that conjugal rights is also a part of the marital framework that the law has put in place. And we weren't actually saying that the restitution of the conjugal rights can be mandated on anyone. We understand that that cannot be the case. In fact, we also say it cannot be the case. If it is cruelty, they have to be separated.
Exactly. At this point, I would like to pitch in saying that, as has been heard repeatedly over time, now the speakers against the motion are primarily concerned with the branding of the accused as a rapist, let alone seeking the remedy that is already available to them. With regard to the submissions made by speaker number one, I would like to submit that the fact that half of our population lives in suburban or rural areas and does not have recourse to knowing what actions lie as in response to the violation of their rights is lack of education. You cannot counter lack of education by pitting it against a social class specifically created to contain and maintain the institution of marriage, which is a fundamental unit of society. And again, like I said, the punishment in this regard, as far as the exception goes, might...
Anurag, your time's up.
Okay.
There's just one point, if I may be granted a little liberty.
No, I'm sorry, I wouldn't be able to do that.
Thank you. Thank you.
I bet you guys have covered more than enough points in your favor. I would request from the speakers against the motion to take the rebuttals.
Thank you, ma'am. So I will explain and rebut one by one. Firstly, as stated repeatedly, that there are alternative remedies provided under IPC or the Domestic Violence Act or any other act. With respect to this, there is as I said earlier, rape is a different offense, and the offense which are defined under section 498A or section 3 of Domestic Violence Act or any other provision of any act are different. Do not compare the rape with any other offenses. Firstly, this is my submission. If a wife can lodge an FIR against husband under section 498A or section 3 of the Domestic Violence Act, then she should also have a right to lodge a complaint under section 375 of the IPC. This is my submission with respect to the remedy available under other provisions. Secondly, when it comes to the intelligible differentia, secondly, I would like to deal with the Anurag's argument with respect to the labeling of husband as a rapist. When it comes to this, if a wife lodge a complaint under section 498A or a section 3 of DV Act or file a divorce petition, then the marriage is protected, or then there is a no tarnishing of image of husband. But if a wife lodge a complaint under section 375 of rape, then it could create a problem, or it label the husband as a rapist. If there is wrong in the marriage or in the conjugal rights, then it would affect whole institution of marriage. And it's not about labeling of a person or labeling of a husband. It's about that there is an offense committed by a husband and then shall be treated as equally. And there would be no differentiation on the basis of just basis of relationship. Perpetrator.
Ajay, your time. Thank you so much.
Okay.
No, I'm so sorry. I didn't give any extra time to the other side as well. All right. Thank you so much, everyone. I think all the speakers spoke really well. Now we'll move on to the question answer round. I would request everyone, whoever has a question, to put it in the chat box so that I can ask whoever speaker you've asked that question from. But before that, I have a few questions. So first question I have is from Anurag Pandey. My question is, and this is because you had made a point about presumption of absence of consent in terms of section 114A of Indian Evidence Act. Now, there are 2 points, there are 2 presumptions which are there, and I want to understand how would you think they counterbalance each other. One is presumption of innocence until proven guilty versus a presumption of absence of consent. So there are 2 presumptions, one in favor of the person who's accused. In this relationship, it would be the husband, and one is for the wife who's alleging such a crime is committed. So how do you think these 2 presumptions act and balance out each other, or what are your thoughts on this?
Thank you for your question, ma'am. My thoughts on these are basically that the presumption of innocence is a phenomena found across the penal sphere, where any accusation needs to be proved. It is counterbalanced by an act where the woman's allegation is presumed to be truth, because in a situation where women have been the victim of violence by reason of marital arrangements, by reason of not having the agency that they would like to ideally have, they are given that leeway to state that whatever they say will not be nipped in the bud, because it is now that the women are getting the agency to come out and speak and talk in the public. But back in the day, when the women really had a chance to put forth their points so that it would be carried off to law enforcement, it was required that it be given to them, so that the husband is put in a position where all the while he was enjoying the privilege of having that exception, specifically with regard to section 375, he may be put in a pedestal where, despite having that exception, he is supposed to prove that whatever happened, that act that happened, it was not rape. Or the moment the lack of consent is alleged, he will have to prove that the consent was in fact indeed present. However, in the current circumstance, like my submission was made, it is not exactly tried to say that removal of exception along with the existence of 114A would really subsist. And for that, the framework of the legislation will have to be changed, thereby amounting to creation of a new law.
Thank you, Anurag. My next question is for Aditi. So, Aditi, you had made a point with respect to mental harassment and how that would not be covered in the scenario of what the other side was speaking of. Um, my submission is that, of course, domestic violence includes mental harassment. So, in such a situation, would you want to reconsider whatever you had submitted in relation to the same?
No, my submission was limited to the fact that a rape, marital rape, or it be a rape with an unmarried woman, is not only cause physical hurt. It also leaves a psychological impact on the person. So, not recognizing it as an offense is unconstitutional, and it is violative of Article 14 as by virtue of the fact that section exception 2 does recognize this as an offense when it comes to unmarried women, but it fails to recognize it as an offense when it comes to married women.
Oh, all right. I just have a very short follow-up question from you, Aditi. In a scenario that you're speaking of, is it the nomenclature which you guys are aiming at, that it should be a 375 case, even though it is punishable in other statutes like the speakers for the motion were pleading? Or what is it that you're aiming at?
Our submission with respect to the other provisions provided under Domestic Violence Act is that those provisions, for example, provision section 498A provides for cruelty against women, and it does not, the offense of rape cannot be equated with cruelty alone. That provision does not deal with rape, and it is not, therefore rape cannot be considered or be taken in the category of cruelty. The punishment provided in the provision does not suffice for an offense like rape.
All right. So I see there are a few questions in the chat box. First one is for the team arguing against the motion. I believe either of you can go ahead and answer the question. The question is, given the seriousness of accusations and weightage given to the lady's statement, can it be guaranteed that there would be no frivolous cases filed?
With respect to this, ma'am, there can be no guarantee for any legislation that it would not be misused, whether it's a civil legislation or criminal legislation. Nobody can give guarantee that this would not be misused. So, however, this could not be a reason that the people have an apprehension. People have apprehension that it could misuse, but this could not restrain the parliament to amend the legislation when such exception violates the fundamental rights, which is unconstitutional. This just the only thing that it could misuse by some wives, it could 498A or any other legislation or provision. We all know that it misused, but this could not be a reason for removing this exception from the code.
All right. Thank you, Ajay, for answering that question. The next question is for the team speaking for the motion, but I would specifically direct this to Anuraag Iyer. So Anurag, the question is, how would you address the disparity in the punishment under Section 375 and other marital laws?
So in response to this query, while I understand there is some degree of inconsistency in punishments, I want to just put another provision out here, which is 376B, which deals with punishments that come in a rape that happens during separated marriages. So if you look at the punishment scale there, it is about 2 to 7 years that you have as a punishment for rape that happens during separation. Our whole submission has been premised from the beginning that the class of married individuals is completely different from the class of unmarried individuals. So when it comes to any sort of an issue, before we go ahead and look at punishment as a problem, we have to take a step back and assess whether we can actually label this activity a rape. Because even if you look at 376B, the purpose behind 376B awarding a lesser punishment of 2 to 7 years is because they believe that the relationship can actually be worked out. The minute you start putting imprisonment into picture and making imprisonment a prerequisite, then it becomes sort of very difficult, because rape comes with a minimum imprisonment of 10 years, which extends further to a quite long duration. So to treat every situation as a normal, and given one more small point, given the stringent nature of rape and its consequences, in every marriage, when I'm entering into a marriage, it will become a prerequisite for me to sit and lay out and make my evidences ready. Because if I'm ultimately possibly going into jail for 10 years based on 114A, then I definitely need to start collecting evidences in advance. That is my submission.
Thank you, Anurag. I see there's another question which is for against the motion, but then I have, I will take this as a follow-up question. There is a preliminary question which I have for the team speaking against the motion. How do you prove rape in a case of a husband and wife relationship? And that is for the team speaking against the motion. Either of you can take this.
This question came before the High Court also, and other cases also. So my submission would be that this would when a rape committed within a boundary of a house, like within a house, the same would be treated or investigated by a police in the same manner as rape investigated by police when it happens between unmarried couple or between like any rape case. There would be no special, there is no requirement of having a special like procedure for investigate a rape which happens in the house. It doesn't require, the police needs to investigate the rape in the same manner as it investigates other rape cases.
Can I just interject once? So I would just elaborate the question that I asked. I understand that the treatment would be same to any rape which has happened, and it goes without whatever relationship one is a part of. My question is slightly different. For example, if a husband and I'll explain by a way of an example. For example, husband and wife on day one had consensual sex, and then of course you have traces of that consensual sex. For example, semen on the bed sheet, etc. Right now, that is day one. On day two, the wife withdraws consent and now says that an alleged rape committed by the husband. In such a scenario, evidence. How would you be able to demarcate the evidence of consensual sex versus rape? And this is, of course, in a scenario where there is no abuse, as the speaker for the motion were claiming.
I'll take this question. So this similar issue was also brought before the High Court, and the submission or the answer that I would like to give to this question is that just because it is this offense would be difficult to prove, or there may not be enough evidence or evidentiary value, or will not have enough evidence to prove the offense, does not mean that the courts will not, or the legislature will not make this offense, or the rights of the women will be taken away on this ground. Just merely because of the fact that it is difficult to prove will not suffice, and it will not suffice the injustice or the discrimination that women will have to face in case their right of in this right is taken away.
I see. Thanks, Aditi, for that answer. There is a question for the team speaking for the motion. That is, allowing marital rape makes the home as the most dangerous place for a woman. Should it not be removed, considering only less than 10% of the total countries remain that allow marital rape?
I'll read that question if I may. All right. Allowing marital rape makes the home the most dangerous place for a woman, based on a very bold assumption, I might add, and a very sad one. However, to take the essence of the question forward, should it be removed? Yes, it absolutely should be, but not in one go. It has been allowed to exist for a large number of years. So when you remove a provision as strong as this, if I may call it, and this is after all of the surrounding counterbalancing provisions have been enacted in order to counter the effect of this provision, if you take this out, a vacuum is created. Allow me to explain by way of an example. When 66A of the IT Act was struck down, the Shreya Singhal case, what happened was that the people writing whatever material on the internet could no longer be prosecuted under it. So what did the authorities do? They went under sedition. Now, when the time comes and sedition completely goes, they will go under UAPA, a more stringent norm, non-bailable offense. So what happens is, if a very strong provision of law exists and you take it away in a wish, a vacuum is created. So in this, as opposed to completely striking it down, what you can do is to read it down, to allow marital rapes to be prosecuted for what they are in cases where it is easier to prove, where it is completely evident that it did happen, as opposed to completely removing husband from the purview of being prosecuted for an offense that you can blatantly see he was culpable of. Eventually, once the society grows around it, the laws bring down their counterbalancing act and it becomes more equitable for different classes of people, is when you can, in addition to reading it down, completely get rid of it. That will be my answer.
So I have a follow-up remark on this. So you're okay with there being a phase-wise removal of this provision? Is that what you're submitting?
That is what I'm saying.
I see.
Which
And there is last question, which is there. This is, in case of offenses outside marriage, there could be cogent evidence. For example, CCTV footage to prove offense. In an alleged offense behind closed doors, does the argument of similar process of investigation sustain? And this is for the tween speaking against the motion.
As many people have raised the issue with respect to the how would police investigate this and how police prove that the rape was committed within the boundary of house, within that confine. So my summation is that first my summation is that it would be difficult for a police to prove a rape when it take place between the when it was committed by the husband. Secondly, there are various other factors or as I would say tool to determine whether the rape was committed or not. Even if in a normal circumstances, when the rape happens, like between unmarried couples or people who are living in live-in, there are cases, there are instances where people are living in relationship, and the girl came out and she lodged a complaint under section 375. So in such circumstances also, police comes out and investigate the matter and file the charges, investigate the matter. On the basis of their report, magistrate take the cognizance. So in the same manner, why we are distinguishing that obviously there is only one difference here, that in one side there is unmarried couple and another side there is married couple. So but there would be no difference for a police to investigate the matter. There are cases like I said, live-in relationship, or people who like consensual sex, but next day the party changes their thought process. Police investigate such matters, and this is something which would be not be new for a police to investigate. Like this would be very common circumstances for a police to investigate a matter. This only difference would be that here the police would be investigating a married couple, and they would investigate, they would go to their house. Murder happens in the house, other offenses happens in the house. Police enter in the house and check the premises, investigate, they prepare the plan, they file the charges. In the same manner, the only difference that the married couple would change the investigation process, nothing. It would not change anything. It would be similar. If police prove that the rape was happened, then they would file a charge sheet and court will take a cognizance. And here I would also address the question of misusing this provision, that if this exception would be removed, then it would misuse by the wives. Then our courts are efficient enough. They have, like, we have a good investigating teams, police departments. They would investigate, and if they do not find any substance in the matter, they will file a charges according to their investigation. So this would not change anything in the whole investigation process, I would say.
Thank you, Ajay, for your answer. Now, there's just last question which is there, and that also is coming from Ajay's present answer, and that is for Anurag Pandey. So the reasoning that you had gone ahead and provided with respect to, and even Anuraag Iyer had gone ahead and provided that reasoning about preserving the marriage, etc. There's a question which comes to my mind is, and what Ajay also just pointed out with respect to the comparison of a husband-wife relationship with a live-in relationship. Now, all the reasoning that you've gone ahead and provided also squarely applies to a relationship, which is a live-in relationship. So do you have any comments on that? Do you think that they're not equally placed only because one is in a wedlock and the other one isn't?
That is correct. And why that is the position is because our laws are keeping up with the times. As of today, and also basis the disclaimer that you thankfully provided at the beginning of the debate, is not all the people who are present in the house today, they conform to a particular thought process, which is for the motion. So it is to say that the laws are gradually keeping up with the society. There have been cases, there have been multiple instances, especially in the recent times, where the courts have awarded recent level of same level of protection to live-in couples, which is at par with married couples. However, once since live-in relationships are not particularly governed by a set of rules, set of laws, a set of responsibilities that come once they are into a live-in relationship. Also, the fact that there is no particular definite chronology as to when a live-in relationship began. And there are no documents to that effect. So lack of documents and evidence, and again, a word of one person against the other makes it very difficult to put it on the same pedestal. However, violence against, like I said, spousal violence of all kind is wrong. And I can only hope that the laws catch up with the times. There does come a time when live-in relationships are accorded equal protection in the eyes of the law, in the eyes of the public also, because as Ajay had pointed out in his first address, education is indeed a very important aspect of taking this law to where it eventually needs to be. That is my answer.
Thank you so much, Anurag, for your answer. Now, I would request everyone, first and foremost, I would like to thank all the speakers for taking our time to prepare for this and actually addressing everyone on this important issue at hand. Now, I would request everyone to go ahead and give their post-debate voting, and then we'll see whether the team who's speaking against the further motion are actually able to do any change in the pre-voting outcome that we had earlier. The time starts now for voting. I would request everyone to give their votes in the chat box. I see a lot of swingers. I'm still waiting for everyone to vote again. In the beginning, there were 29 votes. Right now, only 17 people have voted. So I would request everyone to cast their vote. Another 9 people are yet to vote. I'm just going to give this another 1.5, 2 minutes. But I think even without that, the result is not really going to change. But we'll just wait for the 9 votes to come in. I would request everyone to cast their vote, whoever hasn't casted their vote till now. Request last 30 seconds. I request everyone to cast their vote. Whoever hasn't casted their vote. All right, the voting is now closed. I see everyone was a part to the chat and they could read the chat. So there is no news that I'm going to be giving to the participants. But there are a lot of votes which have been swung in the favor of people speaking for the motion. Initially, they had 4 votes in their favor, and now they have 15 votes in their favor. So 11 votes they have. And people speaking for against the motion had 25 in their favor, and now they have 5 in their favor. So the motion stands, and the winning team is the team speaking for the motion. Now there's a last formality which I have to do, and I've been given great power by none other than Mr. Pintu Babu. The power is to declare the best speaker of today's debate. After quite a lot of deliberation internally, because only I had the power and I did not have to consult with anyone, I have decided that one of the Anurags is the winner. And I wanted to crack this joke throughout this debate. And that's the reason why I ensured that both of them speak together, so that there is a sense of confusion which is underlying in this entire debate. According to me, the best speaker for the debate is Anurag Pandey. I feel he spoke exceptionally well. He defended the motion quite well. And the answers also which he gave in the question answer rounds were quite commendable. So congratulations Anurag,
Thank you, ma'am.
you did an exceptional job. However, this doesn't change anything. You haven't won anything. It's not that you're getting a prize. This is just a validation for your efforts. So congratulations.
Ace is still here in the meeting.
But I was the moderator. So congratulations, Anurag. Congratulations to everyone. And thank you so much for taking out time for this. This was really enriching. In fact, a lot of points that you guys had urged, I wasn't aware of. So at least for me, it was a great learning experience. Another closing remark, which I wanted to go ahead and say from the very beginning was that if these 29 people who voted initially were in fact a society, then as per societal standard test, we would have been living in a very good society, because at least they had that kind of awareness to be voting in against such a motion. At least that's something which I personally believe in. So great work, everyone. And thank you so much for taking out time for this.
Thank you, ma'am.
Thank you. Thank you so much.
Thank you.